Well, good morning again, or good afternoon to everyone, depending on where you're joining us from. We're going to go ahead and get started. Thank you for joining us for today's webinar, Navigating Federal Workers' Comp Crossover Cases in California. Today's webinar is being presented by Gemini Legal. My name is Danica Dorsey, and I'm the Regional Sales Manager with Gemini. Before I introduce our speaker, I would like to cover a few housekeeping topics. This webinar is being recorded, and a link to the recording will be sent to the participants afterwards. And we welcome you to revisit the content yourself and share it with your colleagues, your friends, your family, whoever you think can benefit from this topic. We do have a live Q&A happening at the end of the webinar, so type your questions into the Q&A panel on the bottom of the screen. You can chat it, or you can also email it to rebecca.lawson@geminilegal.com. And here is that email address here. Attendees must watch the entire session to receive the full MCLE credits. And also, all participants are muted. But please don't be shy. Use that chat feature if you have any questions throughout the session. At this time, I'm going to hand the floor over to our guest, Mr. Darren Sarfi. It's all yours. Go ahead and introduce yourself, Darren.
Well, thank you, Danica. I really appreciate the opportunity to come out and talk to y'all. I am, as you could tell by me using the term y'all, I am from Louisiana, and I'm primarily a state workers' comp attorney. I've done practice in Louisiana workers' comp for 20 years or more, and 17 of that has been dedicated just to representing injured workers. Throughout those years of practice, I've also had my fair share of longshore and Social Security disability cases, but everything has always really been focused on Louisiana state comp. And so recently I was provided this opportunity to start a new firm. And I thought that, federal comp is something that I had been interested in for maybe the last 5 years, because there was nobody in our state that did it. And we were one of the larger plaintiff workers' comp firms in the state at the time. And we got lots of calls from postal workers, and we just didn't know what to do with them. So with this opportunity, I said, you know what, this is now going to be my focus. Because for all of you out there that do comp, I applaud you. I love workers' comp. And it's funny because when I got into this, when the second law firm I started working at, which became the one I was at for so long, one of the guys said, nobody goes to law school to practice workers' comp. It just sort of happens. And that is absolutely true for me. I actually went to law school to be a tax lawyer, and look at me, a workers' comp attorney. But you know what? I loved it. And I love people that are dedicated to representing injured workers. It's so different than personal injury, in my opinion. Because when someone's injured on the job, it's the pain and the financial loss is really just the beginning of what they're going through. In comp, regardless of what state you're in, regardless of what system you're in, they're thrown into this system that often wears them down more than it actually heals them. And so as comp lawyers, it's our job to stand with them when they're at their most vulnerable. And I think to one of my former law partners, he was given this trophy by a client, and it was, the shooting star kind of trophy, and it had the attorney's name, and it said champion of the abused. And I thought, that's what we are as comp lawyers. We're champions of the abused, because we fight for those who are overlooked and they're disrespected and they're made to feel like a burden because they got hurt on the job. And we fight for them because they need it and their families need it. But these are the people that are the backbones of our community. So I thank you for the opportunity to come in and talk about federal workers' comp. It's something that is so overlooked. There's so few practitioners in the country that are doing it. And it's it's the type of area of law that even if you're not going to practice in it, and it is a difficult practice to transition into your law firm,
Mhm.
you need to at least know the basic concepts of it because you are going to end up representing federal or former federal employees.
Mhm.
So again, thank you for allowing me, and I'm ready when y'all are.
Absolutely. Well, thank you for that background, Darren. So true on those key points that you touched on. Well, we're going to jump right on into it. We're going to jump into the first question that we have here. Understanding FICA, the purpose and coverage. Federal employees, what is FICA actually?
So FICA stands for the Federal Employees Compensation Act. It's a program that was enacted in 1916, and it is the federally administered workers' compensation program that provides benefits to civilian federal employees who are injured or develop illnesses caused by their work. So, the first question we always get is, well, what do you mean by a civilian federal employee? Who is that?
Mhm.
And the short answer is it's those who work for the federal government in generally a non-military role. So think of your nurses at the VA hospital, IRS agents, park rangers, for California Border Patrol, customs agents, all over the country, TSA agents, FBI agents, and postal workers. Those are your classifications, your groups of employees that fall under this program when they're hurt in the course and scope of their employment. So, uh, generally, when we say a non-military role, of course, there are going to be exceptions to everything. National Guard members, that's an exception. And one thing that you generally look for is who paid them. So if they're paid by the U.S. Department of Treasury, then they're likely covered. There's some exceptions for some qualifications you have to look for National Guard members. And then you have those situations where maybe there's volunteers at certain federal agencies, doctors who may be on rotation at a VA hospital, state and local law enforcement agents that are assisting federal agencies, those may qualify as well. Um, the system is administered through the Office of Workers' Compensation Programs, which is within the United States Department of Labor. Now, every time I say that, somebody says, oh, it's like Longshore. No,
Mm.
it's not. It's not like Longshore at all. In Longshore, the employers and the insurers pay the claims, and OWCP is going to oversee the compliance and also handles dispute resolution. Now, unlike Longshore, unlike state workers' comp, FICA is funded not by insurance, but through congressional appropriations to something called the Employees Compensation Fund. And so that is a key topic we'll talk about later, but there is no insurance involved. And because there's no insurance involved, there's no insurance adjusters. We have claims examiners that work within the OWCP. It provides all the other benefits that you see under state workers' comp. It provides medical, wage loss compensation, vocational rehabilitation, survivors benefits. There's no settlements in a federal workers' comp case. And that drives a lot of attorneys out of the practice. um, these cases can go on and on and on. Even when they're closed out, you can reopen them. There are things called schedule awards, and that would be like a permanent partial disability. um, Schedule awards, by the way, if you do happen to represent an employee in a California workers' compensation case, if they ever worked at some point in time throughout their career for the federal government, you want to ask them if they ever had a workers' comp claim and did they ever receive a schedule award? Because if so, that's going to set off some warnings to you that you need to start thinking about the what's it called, the California subsequent injuries
Injury.
benefits trust fund. It's like we
Mhm.
call it second injury fund, but that's something
Oh,
you want to be on the lookout for.
absolutely.
Um, the other thing, it's non-adversarial. Now, I find this kind of a hilarious statement because any person that you talk to that's stuck in a federal workers' comp case, they're going to say it's nothing but an adversarial process. But
Mhm.
it's technically considered non-adversarial because we don't have a court system that we go through. So there is no judge. You're not arguing in front of a judge. There's no cross-examination. There's no defense attorneys. It's all handled again administratively with the claims examiner. There are certain appeal processes that you can go through, but it's all within that office, we'll call it. Uh,
And it sounds like it's kind of different. There were some key terms you were using in from state workers' comp. Um, Sounds like there is definitely a difference there.
Yes, and we have concepts like total temporary disability. There's supplemental pay. The theory behind comp, from whatever state you go to, federal, longshore, theoretically it's all the same. It boils down to the processes. It down to the procedures, the venues that you resolve your disputes in or your disagreements in, and the scope of benefits that are available to you. Another key distinction in federal workers comp is how attorneys get paid. There
Mhm.
is no contingency fee award in federal workers comp, and there is no award of attorney's fees through OWCP. So an injured federal worker is going to have to pay that attorney directly. And so we bill our clients, I kind of say like normal lawyers, right? Where
Mhm.
we have to get a retainer and we keep timesheets and we send invoices to clients that they have to review and approve. And that's another thing that I think steers people away from the federal comp practice. It's when you're on a strict contingency fee or even longshore where you're used to just billing and getting paid at the end, it's harder to transition your practice into federal comp.
Thank you for that. Let's go on to question number two. So who pays for the benefits under FICA? I think you touched on it a little bit, but who pays for it?
Yes. So the shorter answer is the federal agency does.
Okay.
So again, no insurance in federal comp. It's all through the compensation fund. And so when so let's say in the beginning, employee gets hurt, assuming they file the correct forms, then they would be entitled to up to 45 days of what's called continuation of pay. That's where the agency, the employing agency or the employer, is going to pay them their regular salary for the first 45 days while they're unable to work.
Mhm.
After that 45 days, then they go over into compensation where they're receiving compensation payments through OWCP. Now, that money that's paid to the employee and the money that's paid to the medical providers on behalf of the employee then gets charged back to the employing agency or the employer at the end of the year. And then that employing agency has to reimburse the fund. So, where you see in a California workers' comp case where there's an insurance company that's paying the benefits based on reserves, and
Mhm.
then every 6 to 12 months, they're going to readjust their reserves based on what exposure they see. That money is gone and they're
Mhm.
never getting it back,
Mhm.
but not in FICA. The fund is always getting their money back.
Oh,
And so that that can create, well, it's intended to create some incentives to the employing agencies to review the amount of claims they have in a year. And if one year is higher than others, then
mhm.
it's supposed to provide some incentive to go back and look at its safety protocol, maybe make ergonomic improvements, focus on injury prevention. And sometimes they do. But because these cases never close, meaning you can have an injured federal worker receiving comp for, well, I have some over 20 years, over 20 years receiving comp payments and receiving medical treatment. That bill is going back to the agency every single year. And so they have to put these claims into their budget.
Mhm.
And so it can be difficult for a manager, supervisor, postmaster, whatever, as they're trying to work from one budget to the next, because if they end up having a claim that wasn't our claims ever really expected, but let's say it's a particularly catastrophic one, that's going to throw their budget out of whack, and it's probably going to throw their budget out of whack for the next, who knows how long. And when that supervisor leaves, the new one comes in, they've got a mess they've got to deal with. They have to deal with, how do we make sure that these claims and that old dog claim that's been around for 20 years, that we're still covering it.
Okay.
Now, here's the other thing about the chargeback system. Just like in state comp, where we see employers that are sometimes apprehensive to report a claim because they're worrying about how it affects their rating, how it affects their premiums. You sometimes see the same thing in the federal practice, okay,
Okay.
where there is motive to, or at least incentive sometimes, to either not report the claim, delay reporting the claim so somebody's not entitled to their continuation of pay, make frivolous disputes over a claim. So that's why it's so important that an injured federal worker understand the rights that are available to them, and really be proactive in taking those first steps and knowing that there's more going on behind the scenes with that supervisor as to whether or not this claim is getting reported on time or being unfairly delayed.
And that moves us over to the claims process and the eligibility, if you want to touch on that a little bit. I understand there's 5 elements of a claim. If you want to just go run through those and kind of touch
Yeah,
on that. I
sure.
know you had did that in question number 2, but if you want to elaborate on these.
Well, no, we'll go into a lot more detail, because just like in state comp, you have your certain things you have to prove. We have the same in federal comp. The first is timeliness. The claim has to be filed really within 3 years. Now, I told you about that continuation of pay. If it's a traumatic injury being it happened within one shift, you want to file that CA1 within 30 days to protect your eligibility for continuation of pay. But sometimes they don't recognize the nature, the extent of the injury for much longer. Or sometimes they're just dealing with it on their own, and then they decide, hey, I got to report this. So they have 3 years. The same applies for an occupational disease. Occupational disease in federal comp is anything that occurs over more than one shift. So that can be degenerative neck and back issues. Sometimes you don't even have to file a CA1 or a CA2 for an occupational disease. Technically, the procedure manual says that anything in writing, so as long as it puts the claims examiner on notice that you're making a formal claim, that would be covered. But and then if you're able to prove that somebody knew about it, a supervisor knew about your injury, then you can even get around that 3-year limitation. Then you have to prove that you're a federal employee, civilian federal employee, what we just talked about. Fact of injury is the one that does get complicated, because there's actually 2 parts to that third component. You have
Okay.
to prove that it actually occurred, the event actually occurred. And in federal comp, we do have very relaxed rules of procedure, very relaxed rules of evidence. In most cases, the allegation of an accident, a traumatic injury, is going to be accepted unless the employing agency is able to put forth some substantial contradictory evidence. But then you also have to have your diagnosed medical condition. And that's where we always run into problems because injured federal worker may be going to a, whatever you want to call your doc in the box for your local area, and they're treating with nurse practitioners or physician's assistants, which no slight against them. They're excellent at what they do, and we need more of them. But unfortunately, in federal comp, they're not considered a medical provider. And so somebody may be treating for the first 45 days with a nurse practitioner or a physician's assistant. And when that 45 days is up and now the claims examiner has it to review for ongoing compensation benefits, they're going to disregard all the medical unless the notes from the PA or the NP have been co-signed or endorsed by a physician.
Okay.
So
Let's move on to stress and psychological claims. Under what circumstances are stress or emotional distress claims covered by FICA? I know this is a big topic, even just in where we're at now, mental health, with all that. Can you elaborate on that?
yes, these are unusual in that when you have what you might consider in state comp a pure mental claim, pure psychological injury, they're always so hard to prove. Not so much to get compensable under the federal system. You do have to have more evidence than just your allegation but working in the toxic work environment, being in the toxic work environment, that is enough to create a stress or depression or an anxiety and mental health claim under federal
Absolutely.
comp.
Absolutely.
We have a rule, it's called the Cutler Rule. Lillian Cutler was the case, and it said that stress-related claims are compensable if the emotional condition stems from the performance of the assigned duties. So it's not enough to say my job is stressful, but the stress has to result from something objectively tied to the work itself,
Right.
not just from wanting a promotion or not liking your supervisor or being unhappy with where your career is going within the federal government. But working too much overtime, that can be a stress claim.
Absolutely.
And so, and things like that, they're unheard of in state cases. We see a lot of postal workers developing anxiety claims after being harassed by supervisors. But in situations like that, you have to have evidence, you have to have emails or filed complaints, witness statements. Now, another feature in the federal system is that employees can file EEO, equal employment opportunity claims. And they can do that on a number of different bases, but we'll see it a lot as discrimination one way or another. And often those claims will be settled. A settlement of an EEO claim does not determine that a stress claim or does not in and of itself show evidence of whatever the stress-induced circumstances are in federal employment. But if they do settle, if there is a judgment, a decision by the EEO of discrimination, of harassment, then certainly the claims examiner is going to have to give that significant weight. We see VA nurses with PTSD, either from just the type of injuries that may come through the trauma room or in dealing with other mental health patients. But situations like I want to transfer and I can't get it. Well, that's not going to be covered. Or I'm disappointed that I didn't get promoted, or I'm not getting enough support at work. Well, then that's what they consider frustration, and that's not going to be a compensable injury. But it's important to know that not only could your mental claim be tied into conditions like chronic pain, which we see all the time in state workers' comp, but also due to the circumstances that the employee has to deal with after the injury is reported. Maybe they're not accommodating the work restrictions. Maybe they're putting too much pressure on that injured worker to perform and saying, if you don't do this, we're going to have to let you go. Well, I mean, that's creating harassment, and that in and of itself may be enough to file a separate claim for anxiety.
Okay. Thank you for that. Let's go on to identifying crossover cases. So now we kind of get over into that crossover between workers' comp and federal, or between state and federal. How can California workers' compensation attorneys identify potential crossover cases in their existing caseload?
Well, I think the first thing that any attorney in California needs to ask is, first, who's paying them?
Mm-hmm.
Okay, because we love to have a workers' comp case with a third party case because we can use the workers' comp case to fund the general damage aspect of the third party case. And also, the client is receiving compensation benefits, so they have something to hold them over while they're unable to work and while the third party litigation is going on. If they're injured in the course and scope of their employment, you should not dissuade them from pursuing a federal workers' comp case because, let's take it in the context of a car accident where you might have minimum policy involved. Well, that workers' comp claim is going to be much more valuable to that injured worker later on than the third party case. Now, I think that questions that need to be asked also are not only who's paying them, but where they were working. Are they working on federal property? Are they working on state property? So is there that third party claim? If an employee comes in or a claimant's coming in, client's coming in, and they're using these terms, CA1, CA2, continuation of pay, those are more signals to the attorney that, okay, there is another case here. And even if the attorney is not going to handle that case, the federal workers' comp case, make sure, hey, are you doing this? Get those benefits, get the medical treatment. Now, I do need to tell you that there is no compromise on a federal workers' comp lien. So you can negotiate with the IRS. You can often negotiate with child support, but you do not negotiate with OWCP. They have very strict rules in a form. It's called a form 1108 that takes you through the calculation on what they get. But basically, in any recovery, the attorney is going to receive their fee and their costs. Of that net, 20% goes to the claimant. And then the remaining goes to OWCP to the extent that they have a subrogation interest out there. They will reduce their lien by whatever pro rata share the attorney's fee is, but they get paid. So there's no getting OWCP to waive their lien and moving forward with or waive their lien in exchange for a settlement. Also, like in state comp, if there's money left over, then the OWCP is going to get a credit for that. So we'll run into these situations, though, where we get the question of, well, then why should the claimant even reach out to another attorney? And it's because the OWCP is going to basically force the injured worker to pursue a claim, either themselves or assign it to OWCP if there's third party liability. And if they don't, then they lose their right to that case or to those benefits. So you'd rather have an injured worker with an attorney who's going to prosecute the case in their best interest and not somebody who may be contracted by OWCP to prosecute the case just to try to get some money back for the government. So I think that is really what you want to be looking for. Who is it? If you're going after dog bite cases, you're going to get postal workers. And those
That's
cases,
actually that's actually a good question that you bring that up. Sorry to interrupt, but we do have some questions in the Q&A, and I know that does it sounds like it was kind of the question was going to be right along the lines of what you were going to say in terms of we're going to save a couple of these questions for last, but what type of workers' comp injuries are the most common for federal?
post office, it's going to be lifting injuries,
Mhm.
especially when the post office, I think it was end of last year, had the deal, or last year had their deal with Amazon, where they're taking on so many more Amazon deliveries. Um, the uh, so you see lifting injuries, you see car accidents, and you see dog
Mhm.
bites. And
Mm,
the dog bites usually also have, the ones I've handled have had some significant mental psychiatric overlay. I've seen some really bad dog bite injuries, and some of these carriers, they don't want to get back out on the street again.
right.
Um, we've had robberies with postal workers, and then TSA. We've had TSA. It's a lot of slip and falls,
Mhm.
some lifting injuries, and then anybody that goes IRS agents that have to go out. Border Patrol that's Border Patrol have heat exhaustion, heat stroke injuries. Um, but car accidents of all kinds. So
Mhm.
it's just about anybody that you would see in um, any type of injury that you see in state, you're going to see in federal. I mean, Tennessee Valley Authority,
Okay.
pipe fitters, they're messing up shoulders and back injuries, just like everyone else is.
Right. Okay. So the crossover between state and federal, what are the key factors that determine whether a case qualifies as a crossover between state and federal workers' compensation?
All right, so I think first thing you have to do is you have to determine, you have to identify the employer. And is the injured worker, again, a federal employee? Um, you can see those situations where, and and Danica, I gotta apologize because when I gave you the slides,
Mhm.
it said I put in there holding a federal position while performing duties in a state covered capacity. What I should have said, I messed it up, and it's what happens when you do the things over and over again. It should be you're a state employee in a federal covered capacity. So that's when you are a police officer and you are maybe assisting FBI securing a scene,
Oh,
um, or you can have National Guard that's performing something in federal duty. You can have uh, contractors that
mhm.
may be private contractors that are specifically contracted by the federal government and have authority to be on federal premises. Those types of situations, you might have a state employee who's actually working in a federal capacity and would be covered, therefore, under federal workers' comp. But then you can have the times when you're going to have a federal employee with a crossover, a California crossover case, is generally when they have that third party type liability.
Okay. So we actually have a chat here or a question here in the chat that I'm going to give to. We have about 20 minutes left, so I do want to get these see if we can get these answered as much as we can. In a dog bite third-party settlement via the civil court system, does the federal government have a statutory right to full reimbursement for federal workers' comp benefits paid even though the injured postal workers paid the full cost of pursuing the civil claim and sorry, I lost my apology. The civil claim and the federal workers comp program did not participate in the civil action against the third party tortfeasor. Example, the owner of the dog, the owner of the dog. So
All
it's in the
right.
chat if you need to reference that, and we can get an answer to Mr. Edward.
This might be an easier way to put it. If you represent a federal employee and they have, in a third party case, ask that client of yours if they have received a letter from OWCP asking about a third party case. OWCP is going to screen these cases. And if they think there's third party liability, they are going to reach out to the claimant and ask, are you pursuing this case on your own? Do you have an attorney? And if you don't, then assign the claim to us and we will pursue it. It's actually not by OWC, it's the solicitor's office through the Department of Labor. But they're putting them on notice that, hey, if you have an attorney, you need to let us know. And so, from the attorney standpoint, the third party attorney, if you know that they have an open claim, so you should be asking the client, you got bit by this dog. Did you file a CA1?
Mm.
Do you have access to ECOMP, ECOMP? That is the online database for all federal workers' comp claimants. That's where they upload their documents into. That's where they file their CA1. That's where they upload their medical records. And anything that they get in the mail is also going to be in ECOMP. It's like getting your adjuster's file in your state workers' comp case. So, out of an abundance of caution, the attorney should have a letter, even if it's just a to whom it may concern. I represent this person in a third party case for the dog bite that occurred on such and such date. Please contact me directly if there is a lien, and tell your client, upload that into eComp. And if they say, I don't know how, then you tell them, designate me as your representative and I will upload that document into eComp and then I'll get out. Because remember, let me just say this. When you're in eComp, designated as a representative, then OWCP thinks you're the lawyer. Even if you're just saying, well, I'm not doing anything, OWCP thinks you're the lawyer on it. So you might want to have some documentation with the claimant confirming that you're not representing them in that. You do your due diligence and you do your part by putting that letter in the file. The solicitor's office will contact you. And if they have paid anything, they're going to want their money back, subject to the formula. And again, that's on I think it's the CA 1108. If you email me directly, I'm happy to send it to you or even talk you through it a little bit more. But
Awesome. Okay, so I want to get through we have 2 more questions. There's about 8 questions we have, and then I definitely want to leave some time and room for our audience to ask some questions. So guys, don't forget, use the Q&A down below and type in your questions and we can see if Darren can get those answered for you. So dual benefits, state versus federal workers' comp eligibility. I think we maybe already covered a little bit of this, but can an injured worker receive benefits from both state and federal workers' compensation programs simultaneously?
When you asked me that, I was thinking, is that possible? It really no, but I want to make it happen. I'm guessing if you had an employee who was working for the federal government and got hurt and is receiving compensation benefits, see, they don't compensate in federal, they're not going to compensate them for other lost wages from a private employer. So it's just based on the salary, not even based on overtime's not even included. just based on salary. So theoretically, if they were working for a private sector employer and they got hurt for a different body part, maybe they could make a claim, have their claim for compensation benefits from the Fed, and then have a separate claim. If it's shoulder for the Fed and then knee for the private sector, maybe so. But the other time I would think this would be more common would be somebody worked for the federal government, they got hurt, went through treatment, declared maximum medical improvement. They have their impairment rating. Now they're drawing their schedule award. Okay. It could be, let's say it's 26 weeks of benefits paid out on their schedule award. And now they have left federal employment and they're working in the private sector. And now they get hurt in the private sector. They could be drawing their schedule award because schedule award's not paying for lost compensation. It's paying for impairment. And then you're receiving state compensation benefits for the new injury. That's probably the only scenario where I would see that happening. And as a plaintiff attorney, big red flags though, because you need to know, all right, give me all the details about that prior injury, because that's the kind of stuff that the defense attorney is going to go bonkers on.
Okay. So coming up on our last question here in the slide, transition FICA case into federal attorney, or transition your FICA case to a federal attorney. How can a state workers' comp attorney transition a FICA case to a federal attorney? I think this is one of those big juicy questions that a lot of these state attorneys would like to know kind of what that process looks like.
Yeah, I say first thing you do is just pick up the phone and call the attorney. Call me. I'll talk you through it. Because clients got to pay me directly, I need to make sure that I'm bringing value to them. Somebody doesn't hire me to stay on their case for years. They hire me to resolve a particular problem that they're having in the case, and then they can always come back and ask questions and we can decide if something else needs to be done. But in order to really understand what's going on in a federal workers' comp case, you have to get into their file. And you just decide. It's kind of like asking the TPA to send you a copy of the claims file. You did need to decide if that's what you want to really get yourself into. So first thing to do, once you know you have a client who, or somebody comes to you and says, hey, I'm working for the post office and I got hurt and you're a workers' comp attorney, can you help me? Instead of telling somebody no, have the relationship with the attorney that handles this stuff. I go all over the country talking to lawyers, and what I tell them is, I'm in Louisiana and I'm just a comp attorney. I am of no threat to anybody else's practice. I am a tool to help expand your network so that you never want to tell somebody I can't help you.
Right.
Even if it's just, I will put you in touch with somebody that you will like and you will trust because I've talked to this person and he or she knows what they're talking about. You, as that attorney who they went to the first time, look great because you went out of your way to help them. So the short answer is, how do you transition it? Send the email to the attorney. I got somebody that's going to call you, or tell the person, call this person and let them know I sent you. Don't get into the file if you don't want to. It's, now you're just looking through pages and pages of stuff and you're looking at medical records. And another thing I didn't tell you, there's no presumption of causation in federal comp. Federal comp requires what's called a pathophysiological explanation, meaning it's like a mini, talking about the shearing and load on joints and tendons that caused it to fracture or strain. And so you might be looking at this stuff saying, well, the doctor said it's related. What's the problem? You got to dig deep and say, well, is that just a conclusion or did the doctor show their work?
Mm,
and explain how they reach that conclusion. So just build a relationship with a lawyer like that. Once you do that, you can tell your postal carrier, your mail carrier, hey, if you get hurt, we know somebody that can help you. Think about what that does to that postal worker now who says, wait a minute, out of all the law firms I deliver to, I know somebody now that can help me if I get hurt.
mhm.
May not be directly, but that's the start. And that's what these people need. Federal workers need a place to start because there's so few people around the country that do this. So
And
be the champion of the abused
mhm.
and tell them, never tell somebody I can't help you. Have the relationship to send them in that direction and be the first one to actually help them.
And those are good qualities to look for when you are transitioning your cases to a federal attorney. I believe you hit it right at the beginning. Is you're responding with seeing if you can first offer value to the injured worker, to the attorney. And so I think for all the state attorneys, that those are good qualities to look for when you are transitioning your cases to a federal attorney. We have a question. What are common mistakes attorneys make when dealing with OWCP liens, and how can they be avoided?
Number one is they don't find out if there is a lien.
Mm.
And
And
it's because they're not in communication with that claims examiner. Most of the time, they stay far away from it. They say, we don't handle federal comp. We don't know anything about federal comp. Client, you're on your own about that. And the client isn't paying any attention to the letters that are coming in. Or maybe they got that letter early on in the case before they hired the lawyer. So ask the client. If the client says, I don't know, you say, go back in your file on ecomp and look through all of the outgoing correspondence. They're set up in sections. It's, forms and fiscal and medical and incoming communication and outgoing communication. Outgoing is going to be everything that the claims examiner or OWCP is sending to that claimant. Tell them to go through there and find out, did you receive a subrogation letter? There's many categories, subcategories. Look for subrogation. If it says one, they got a letter. And then tell them to print it up and give it to you or screenshot it and send it to you so that you as the third party attorney can cover yourself,
mhm,
because these federal cases, they can be very, very important and very valuable to these injured workers.
absolutely. And then we have another one from our audience. How do we elect doctors in a crossover case?
Okay, excellent point. I wish in federal we had more doctors that were willing to accept federal comp.
Mhm,
That is a struggle. And so if you have somebody who has a federal comp case and you are handling the third party and you have your connections, you have your doctors that you prefer to work with because you trust them and you know that you can get reports from them and you know that they have good bedside manners, then you want to find out if they accept OWCP. If they don't, talk to them about it. Call me. I'm happy to talk to the doctor. I want to talk to as many doctors around the country and explain to them really how easy it is to do this stuff and to get paid on it. And if your doctors don't do that, then you've got to make the decision. Well, are you going with a doctor that you may not know that does accept OWCP, or are you just saying, well, we're not going to use OWCP approved doctors on this one? You could, if you had the client pay for the treatment, you could send the receipt into OWCP and then they will reimburse it under the reimbursement schedule. And so that is an option, but that's more time and paperwork. Another thing I'll tell you, chiropractors are not like in Longshore. They are not. They're given no weight, unless they're treating subluxation that's been confirmed by x-ray. So if one of your standard procedures is person gets rear-ended and you get them off to your favorite chiropractor to get them worked up, don't expect OWCP to cover that unless the x-rays show subluxation.
Okay. Very good. Well, it looks like it's time for us to wrap up. If
Oh,
anyone has, I know we're having so much fun. This is
I'm enjoying this.
Honestly, this is so informative. I can't wait to listen to the recording and send it to all of my state attorney friends. But this is very informative, Darren. Thank you so much for taking the time out to join us and have fun with us today. Very insightful information that you shared on your on federal on FICA as well as your expertise. If you have any additional questions or you would like to connect directly with Darren or his team, let me see here. Let's see. Here's information is here at the bottom. You can take this down and contact him directly, as you see on the screen there. So any finishing touches you'd like to add, Darren? We have about 5 minutes.
You know, only if I get started, I'll probably just keep carrying on.
Yeah, we definitely want to give them a little, give them their 1 o'clock hour back. But yeah,
Yeah,
if anything, you
no,
want to just wrap up and give a little finishing touch, that's totally fine.
yeah, this is it's an untapped market. It's an untapped community of workers, and even if you are not going to dive into this area of practice, which if you do, I welcome you into it. But you know, let the people that you know that work for the federal government. You'll be surprised how many postal workers you're gonna encounter. Let them know that if they get hurt, you know somebody that can help them. They can come to you immediately. You're going to stand out in their mind as the first person to call, even when they have a friend or family member that's asking them for a lawyer. Why? Because you have now reached out to them and said, I can help you in your weird situation that you're in.
Mhm.
And so I think it's a wonderful marketing opportunity. And so just keep that in mind. And if anybody has any questions, if you've got something in your file in your file cabinet and you're not sure what to do with it, call me, email me. As you can tell, my problem is I talk too much. And I am happy to
No.
talk to any client, any prospective client, any federal worker, even if I can't help them right now,
Yeah.
they're going to leave a conversation with me knowing why what situation they're in and when to call me back. And I will let you know that I've spoken to them. The great thing about this practice is meeting attorneys all over the country and just being able to talk comp. And
Awesome.
for
Will you
you,
be
just
joining summer call
what
here?
out there in Carlsbad?
Yes.
Absolutely, I'm going out there.
Absolutely. I thought so.
Yeah,
Yes. So
I
you
will be out there. I'm going to bring my Mardi Gras beads and doubloons again. So come
there
by.
you go. Bring a little bit of some of that bayou over here to California.
That's right. That's right.
I love that. All right. Well, thank you for your time, Darren, and thank you all the audience and the production team that stayed on to make sure all the things worked well during the webinar. You all have a wonderful rest of your day.
Miss
Goodbye.
Nika, thank you very much. I
Thank you
appreciate
so
it.
much, Darren. Have a
Yes,
great
ma'am.
day.